please be upstanding. For His Honour, Judge Stein.
Thank you. Please take a seat.
So, a number of months later, you may or may not be surprised to learn that Mr. Brown was charged with the offence of causing death by dangerous driving. During the criminal proceedings, as is quite usual, the Crown, who bring the case, added a second count of causing death by careless driving. And that's because if they can't make you sure, they like to have it both ways, if they can't make you sure that the driving was dangerous so that it fell far below standard, they also say, well, okay, if you don't find that it was careless, find that it was below standard. So they give you that alternative, and that is very, very usual in a case such as this. The company were charged under Sections 2 and 3 of the Health and Safety at Work Act 1974. And at long last, Ms. Bryony sought legal representation. Mr. Brown entered not guilty pleas to both charges and stood trial at Coventry Crown Court. The company pleaded not guilty to both offences. Ms. Bryony attended court as managing director on behalf of the company. Now, again, we are asking you a little bit here to suspend some reality, because in reality, these trials would take place in two separate courts on separate days. They wouldn't be joint trials in any way. You wouldn't have the same firm or barristers representing both of these parties. Why? Well, apart from anything else, there's a conflict, isn't there here? There's a clear conflict, okay? But even where there isn't necessarily a conflict, you wouldn't have that. So again, for the purpose of today, to be able to show you both proceedings, we're combining the two. And now, if you remember before the break, we're right back to where we started. So I'm going to leave you in the capable hands of His Honour, Judge Stein.
Thank you. So, members of the jury, as I said before, I have to give you some opening words to try and explain your role in any trial. Unusually in this case, I've also got to speak long enough for prosecution counsel to get changed. So I'll do the best I can in relation to that. It's quite unusual, I'm afraid. But in any criminal case in the Crown Court, you, the jury, and I, the judge, have different parts to play. And I'm responsible for the legal matters, and I tell you what the law is and how you apply the law to the case. And in relation to any legal directions, you must accept what I tell you about the law. You have to follow that legal direction. I also manage the barristers when I can, and ensure that the evidence that you hear is fair. But you are responsible for weighing up the evidence. You decide the facts of the case, and it's entirely up to you to decide what evidence is reliable and what evidence is not reliable. You don't have to decide every disputed point that's raised in the trial, only those that are necessary for you to reach your verdicts. Where there's conflicting evidence, you decide how reliable, honest, and accurate each witness is. When doing this, you must apply the same fair standards to all witnesses. This is a case that involves a fatality, and in every such case, it will likely arouse feelings of sympathy or emotions in you. When it comes to making your judgments about the evidence and determining your verdicts, you must put emotion to one side and take a fair, careful, and reasoned approach to the evidence that you've heard. As some of you will know, no one can be convicted of any offence in this country unless the prosecution have made you sure that he or she is guilty of that offence. And that applies to a company as well as to an individual. The prosecution must prove that a defendant is guilty. No defendant has to prove anything to you. He does not have to prove that he is innocent. And the prosecution only succeed in proving guilt if they've made you sure of it. If after considering all the evidence, you're sure that a defendant is guilty, your verdict must be guilty. If you're not sure of guilt, your verdict must be not guilty. All right, thank you. So what we'll do now, members of the jury, please listen carefully to the evidence, take whatever notes you need to, and I'll hand over now to prosecution counsel, who's going to open the case for you.
Thank you, Your Honour. May it please, I appear on behalf of the Crown today, and my learned friend, Mr. Rosser, appears on behalf of the defendant. On the 18th of December 2022, the defendant was driving his HGV along Leabridge Road at the junction with Bickley Road. A cyclist wearing a bright red jacket was in the cycle lane. The defendant turned left, colliding with the cyclist, dragging her some way before stopping. Tragically, she died as a result of her injuries. The defendant will say he failed to see the cyclist, who had priority. However, at the scene and later in interview, the defendant admitted that he'd seen the cyclist just moments earlier. The defendant states he was not aware of the collision until he was waved down by a member of the public. Importantly, analysis from the defendant's mobile phone showed that he'd been on a hands-free call that ended about a minute before the collision. The prosecution will say this supports the notion that he was not fully concentrating in the moments leading up to that collision. The defendant also admits he hadn't slept well the evening before, which the prosecution say is irrefutable evidence that he was distracted and tired. And you might think, importantly, that the defendant's admissions at the scene are crucial when you're determining this case. The camera, which gives a view of the near side, was not functioning, nor was one of the near side sensors on the truck. However, the prosecution will say the defendant had access to other technology designed to assist him in detecting pedestrians and cyclists, but he ignored it. It had become custom and practice for him and others within that company to disregard the warnings from these systems, which were specifically installed to prevent such tragedies. This habitual failure, the prosecution say, to heed those safety alerts significantly contributed to this collision. Members of the jury, Rule 140 of the Highway Code states that you should give way to any cyclist in the cycle lane, including when they're approaching from behind you. Do not cut across them when you're turning or when you're changing lanes. Be prepared to stop and wait for a safe gap for the flow of cyclists before crossing the cycle lane, and you should give way to cyclists approaching, using the cycle track, and when you're turning in and out of a junction. The Highway Code also imposes a strict hierarchy for road users, which places those road users at the most risk in the event of a collision at the top of that hierarchy, including users such as cyclists. We say this places an even greater burden on Mr. Brown to ensure the road was clear before he turned left. And having seen the cyclist only moments earlier, he ought reasonably to have known the cyclist was there. In addition, Mr. Brown ignored warnings displayed on his vehicle, advising him to take a break, advising him it had detected signs of fatigue. By habitually ignoring this technology in place to assist him, the defendant, we say, demonstrated a reckless disregard for his responsibilities as the professional driver. This, coupled with his lack of concentration and fatigue, meant that his actions fell far below the standard expected of a competent and careful driver, and those actions directly caused the cyclist's death. Now, members of the jury, I would like at this point to show you some CCTV footage which was captured 50 metres west of the junction with Bickley Road. What I would say at this point is this footage is not in any way gory or gruesome, but it does show a collision. So if anybody is of any kind of sensitive nature or have been affected by anything like this, you may wish to turn away. But this is the footage of the collision, if we can play it now. You'll see Mr. Brown's vehicle coming into the frame, turning left. I think we probably have a closer visual. Okay, that's something you need to take into account when deciding upon the case, members of the jury. Now, Your Honour, with your permission, I would now call the first witness for the prosecution, Mr. Rob Beckers, a forensic collision investigator instructed by the Met Police to investigate this case, as is usual. Now, ordinarily, I would take the expert through his qualifications, followed by his evidence as examination in chief. So effectively, I would just walk him through his evidence. But for the purpose of today, I'm going to allow the expert to present his findings to you directly.
Thank you. So, Mr. Wendham, please.
Thank you. The collision occurred on the A104 Lea Bridge Road at the junction with Bickley Road, Leighton. This is a major through route in East London running generally northeast to southwest. The area is built up with commercial properties on both sides. The incident took place where the cycle path intersects Bickley Road on the left side at its meeting point with the A104 Lea Bridge Road in Leighton. This junction is a staggered crossroads with Russell Road on the offside. The road is straight and flat, marked with double yellow lines, and has a cycle path distinct from the pedestrian footpath. The road surface was dry and the weather conditions provided good visibility. Mr. Brown was driving a white Scania R500 XT articulated lorry southwest on the A104, intending to turn left into Bickley Road. The vehicle had mandatory mirrors, close proximity mirrors for slow speeds, and Class 2 mirrors for general driving. It was also equipped with 5 cameras, including 2 near-side cameras, 1 elevated behind the cab, which was forward-facing, and another above the rear wheel arch, which was rear-facing. Fatigue and distraction detection technology monitored the driver, alerting him to take a break multiple times that afternoon. The final alert was 48 minutes before the collision. The driver could view camera footage via an in-cab monitor with warnings displayed on the dashboard. The elevated near-side rear-facing camera was faulty, displaying images intermittently. The cyclist, Anne White, was travelling southwest parallel to the Scania. CCTV footage was obtained from the Scania's camera system and local authority cameras 50 metres west of the junction. A reconstruction was conducted to establish the relative positions of the Scania and the cyclist. As the Scania neared the railway bridge, the cyclist was on the opposite side, directly in Mr. Brown's sightline. She remained visible for approximately 5 seconds. As the Scania drew level, she would have been seen in the near side rear-facing camera had it have been working. After the front of the Scania passed her, she would have been visible in the Class 2 and Class 4 mirrors. As she reached the front offside corner, she would have been visible in the Class 5 mirror. Mr. Brown's evidence suggests that as he swung outwards into the offside lane in order to make the turn, his attention was to the right lane. Having seen the cyclist prior to the junction, he ought to have been tracking her movement to confirm her position as he proceeded to turn left. In my expert opinion, the collision occurred due to Mr. Brown failing to check the cyclist's whereabouts and failing to observe her crossing the junction, despite the cyclist being there to be seen.
Thank you very much, Mr. Beckers. There might be some questions from my learned friend.
Yes, Mr. Rosser.
Mr. Wenham, it's right that you're instructed on behalf of the Metropolitan Police, isn't it?
That's correct, yes.
And in fact, despite you being an expert witness of some experience, You've never given evidence on behalf of the defence before, have you?
No.
Now, Mr. Rosser, what's the relevance of this, please?
Well, Your Honour, I'm sure the jury are interested in the fact that the prosecution have presented an expert who's never, despite indicating they're independent, given evidence on behalf of the defence. But of course, ultimately, Your Honour, a matter for the jury in due course.
Have the defence raised any issues with the prosecution expert's admissibility?
Your Honour, I don't dispute that he's an expert and has the relevant qualifications.
Right.
I solely make the observation that the prosecution have presented an expert with no experience whatsoever in giving evidence on behalf of the defence.
But as you know, Mr. Rosser, an expert gives evidence on behalf of the court, doesn't he? And an expert witness, in order to be admissible, has to sign a declaration that says that their evidence is for the benefit of the court and doesn't, as it were, and the party that he's been instructed or she's been instructed by doesn't make any difference to that evidence, does it? And the defence, in this case, haven't objected to the admissibility of this witness's evidence, so I suggest you move on, please.
I'll move on, Your Honour, but I'm sure the jury have the point. Mr. Wenham, we can see from the CCTV that as Mr. Brown's vehicle approached, the cyclist was ahead of him on the near side footpath rather than the cycle lane. Is that correct?
Yes, that's correct.
And so when you told us before the cyclist was travelling southwest parallel to the Scania, for completeness, that should say they were travelling southwest parallel to the Scania on the pedestrian footpath. That's correct, isn't it?
Yes, that's another way of putting it.
And in fact, at no point during your evidence to the jury when you were asked by the prosecution, did you make any reference at all to the fact the cyclist was travelling on the footpath, did you?
Not directly. The cyclist was travelling parallel to the vehicle.
At the point when the cyclist was travelling parallel to the vehicle, as we've established on the pedestrian footpath, would you consider the cyclist a hazard?
Not an immediate hazard, perhaps, but she was travelling towards the junction Mr. Brown was about to turn into, and it was incumbent on him to ensure the junction was clear, so he should have been alert to the cyclist's movement.
And from the reconstruction, as Mr. Brown's vehicle catches up with the cyclist and draws level with her, still on the footpath, can Mr. Brown see the cyclist directly out of his windscreen?
No.
And what about in Mr. Brown's near side mirrors? Could the cyclist have been seen there?
No, but she would have been visible in his near side camera at that point, had it have been functioning correctly.
Well, is there any obligation on Mr. Brown to use the internal monitor in his cab to view the camera footage on a separate screen while he's driving?
Yes, absolutely. It could be used as an additional aid.
You say it could be used as an additional aid. That's not the same as it being an obligation to check that screen, is it? It could be distracting.
It's not an obligation, but if you've got an additional aid there that you can use to check around your vehicle, it's a relevant thing to look into that camera and see what view it's presenting to you.
Well, can we agree, Mr. Wenham, that looking at a screen that's not surrounding the driver, it's not looking at the road, potentially takes the driver's attention away from the road and the manoeuvre they're performing?
Potentially.
It's nice we can agree on something, Mr. Wenham. Now, to clarify at this point, whilst Mr. Brown is adjacent to the cyclist on the footpath, she cannot be seen either directly or by Mr. Brown in any of the near side mirrors.
You've obviously been listening, so yes, you're correct.
I'll take a compliment where I can find one, Mr. Wenham. We know from the CCTV that as Mr. Brown continues to move forward and prepares to turn left, he has to manoeuvre his vehicle to the right in order to negotiate the corner. And we also know that around the same time, the cyclist moves from the pedestrian footpath into the cycle path. Now, at the moment, of time that the driver manoeuvres their vehicle to the right, where would you expect Mr. Brown's attention to be directed?
Due to the manoeuvre, it's necessary for Mr. Brown to check all around his cab.
Well, this is a large vehicle. It's invariably going to move into the opposite carriageway as it completes the manoeuvre. Would it not be reasonable for Mr. Brown to look in his offside mirrors as he begins to turn, manoeuvring to the right, to ensure he does not come into contact with any road users on that side, either coming towards him or coming from behind him?
Very observant, yes, but he is turning left. In that situation, I would expect his attention to also be on his near side, using his near side mirrors to gain that vision.
Well, the cyclist having now moved into the cycle path, adjacent to the vehicle, could the cyclist be seen by Mr. Brown out of his windscreen or near side mirror?
No.
Or in any mirror, for that matter?
No.
And as the Scania draws ahead of the cyclist, would she be available to be seen in either the Class 2 or Class 4 near side mirrors?
Yes, there's a brief moment when the cyclist was available to be seen in those mirrors.
A brief moment. Is that right?
Yes.
There's no set order, is there, in which a driver must check their mirrors?
No, there isn't a set order, but if they are aware of a cyclist along the near side, before performing this sort of manoeuvre, I would expect a driver to check their near side mirrors last.
And there's no evidence, is there, as to the order that mirrors were checked in?
No, there isn't any such evidence.
And so it's possible that Mr. Brown checked his mirrors in a different order, and so that brief moment that you described, in fact, he may have been looking in a different mirror.
Yes, it's possible.
And as Mr. Brown continued his left turn manoeuvre and moves into the junction, the cyclist wasn't available to be seen directly by Mr. Brown through his windscreen or any of the near side mirrors, were they?
At that point, no.
No. You were here for the prosecution opening when we heard the reading of Rule 140 of the Highway Code, which related to give way to any cyclists in a cycle lane, including when they are approaching from behind you. Highway Code specifically drafted to say cycle lane, isn't it?
Mr. Brown accepts that he saw the cyclist. It was incumbent on him as the driver of an HGV to ensure the junction was clear before turning. Having been aware of the presence of the cyclist just moments before, he should have been extra vigilant as to where she was.
Well, Mr. Wenham, what I asked you was that the Highway Code is specifically drafted to read cycle lane, isn't it?
Yes.
Thank you.
So, Mr. Rosser, are you suggesting that it's perfectly open to any driver to simply ignore a cyclist if they're not in a cycle lane?
Your Honour, no, I'm suggesting it's relevant to the jury's determination in due course as to whether the standard of driving in this case fell below the standard of a careful and competent driver, particularly in a case where the prosecution have specifically opened their case on the basis of a breach of a specific rule of the Highway Code, which factually may not apply to these circumstances.
All right, thank you.
Mr. Wenham, finally, does the Highway Code also apply to cyclists?
Well, of course, yes.
Yeah. Can you just help the jury? What does Rule 76 of the Highway Code state, please?
Off the top of my head, I'm not sure. I would have to look up the specific number.
All right, well, I'm not an expert, but I expect I can help you. It says that cyclists should check that they can proceed safely, particularly when approaching junctions on the left, alongside stationary or slow-moving traffic, watching out for drivers intending to turn across your path. Specifically says, remember that the driver ahead may not be able to see you, so bear in mind your speed and position in the road. And it goes on to say, take great care when deciding whether it's safe to pass stationary or slow-moving lorries and other long vehicles, especially at the approach to junctions, as their drivers may not be able to see you. Remember that they have to move over to the right before turning left, exactly as Mr. Brown's vehicle did, and that their rear wheels may then come very close to the curb while turning.
Yes, it also states if you're going straight ahead at a junction, you have priority over traffic waiting to turn into or out of the side road.
Now, just commenting on the movements of the cyclist as seen on the footage, did the cyclist check that they could proceed safely, given that they crossed the junction without stopping with a heavy goods vehicle immediately to their right?
I've not had any sight of any evidence as to the presence or absence of any checks made by the cyclist, and it's not clear from the CCTV. But she did have right of way, and Mr. Brown, as he was driving that vehicle, did have a duty to give way to her.
Thank you, Mr. Wenham. I've got no further questions.
Thank you. Thank you, Mr. Wenham. That concludes your evidence. You're free to go or to wait, depending on what you want to do, but you're released from the trial.
Thank you, Your Honour.
So, members of the jury, in a real case, we now hear other evidence. We might hear eyewitness evidence. We may well have agreed facts as to, for instance, the injuries that were sustained by the cyclist and her trip to hospital, etc., etc. But for reasons of time, what we're going to do is press on and cut straight to the defence case. So what we'll do, please, Mr. Rosser, is hear from you.
I'm grateful, Your Honour. Can I call Mr. Brown? Mr. Brown, can you confirm, first of all, for the jury, your full name?
Paul Brown.
And what's your occupation, please?
HGV driver.
How long have you been an HGV driver?
I've been doing it for around 18 years.
And who are your current employers?
LB Freight.
And were they your employers at the time of the collision in 2022?
Yes, there was.
When did you first pass your driving test?
1994.
And when did you subsequently pass your HGV test?
That would be 2004.
And just help the jury, what does your day-to-day role involve?
Well, I deliver all sorts of fencing equipment on a large HGV.
Just for completeness, your driving licence, do you have any points on that driving licence?
No, I have a clean licence.
You say that you've driven a number of different types of vehicle. It's right, isn't it, that you were driving the vehicle that we've seen on the footage?
Yes, that's correct.
And how long before the collision had you been driving that vehicle for?
For the last 2 years.
So you've been driving it since about 2020, is that right?
Correct.
Having driven it for 2 years, would you say you were familiar and comfortable with the vehicle?
Yes, I drive that vehicle 5 days a week, and the mirrors and the seat position where I want them to be.
Now, turning to your day-to-day work, do you carry out any checks at the start of your day's work?
Yes, I carry out a walk-around check at the start of the day.
Did you carry out that check on the day of the collision?
Yes, I did.
What about mirrors? Is there any check that you do in respect of your mirrors?
Yeah, I check the mirrors in my position and I make sure they're clean for that day.
Taking you back to that specific day, what time had you started work?
6 a.m.
And at the time of the collision, how many more deliveries did you have to do?
That was my last one of the day.
Were you using a satellite navigation system?
Yes, I was.
Now, specifically for this delivery, did you need to use that system?
No, I don't need one for that job. I knew where I was going.
Had you been there before?
Yes.
Were you on your phone at the time of the collision?
No.
Were you distracted by anything?
No.
Were you tired?
No, I was fine to drive.
We've heard from the expert that your fatigue warning system had gone off. Did you notice that?
Yes, it goes off all the time when nothing's there. It's not foolproof.
Moving to Lea Bridge Road, where were you intending on driving from Lea Bridge Road?
I had to turn left onto Bickley Road.
Of course, take the jury back. What can you remember as you approached that junction?
It was quite heavy traffic on the opposite lane. Had to obviously swing out to the right, and there was a parked black car on the corner, so you had to watch out for that as well.
Did you see the cyclist at all?
I did. She was on the pavement next to the cycle lane.
So we've seen on the footage there's the road, the cycle lane, and then the pavement. Is that right?
That's correct.
And so at the time you saw the cyclist, they weren't in the cycle lane.
No, there wasn't.
Where did you think the cyclist was travelling?
There were some shops on the left-hand side, so I just thought she was going into one of them.
I just want to put up a street view, if we can, and ask you just to show us whereabouts the cyclist was when you saw them. I don't know if it's possible to put that on the screen.
Yeah, about there.
About there. All right. And where did you think that she was going?
So one of those shops on the left.
So further on.
Yes.
Right. Thank you very much. Talk us through the turn into Bickley Road. It's just into a single carriageway, is that right?
Yes, it's a single carriageway, and it's quite tight, in particular for a HGV.
And you told us before it wasn't the first time you delivered to that location. Had you been on this route and to this road before?
Yes, I've been quite a few times.
Now, in order to turn left, do you have to move the vehicle out a little bit to complete the manoeuvre?
Yes, you've got to get quite far over onto the other side of the traffic, so you can curl your trailer around the corner.
Before you pull out to the right, where do you check? Where's your attention drawn?
You're checking all around you, you're checking down your near side, and also you're checking in front of you, and also your offside.
When you're carrying out those checks that you've described, what are you looking for?
Any danger, anything what might cause an incident, an accident.
Prior to making the manoeuvre, did you put your indicators on?
Yes, I did, yes.
When did you do that?
A good while before the turning.
Does anything else happen, apart from the indicator illuminating?
Yes, it activates a verbal warning, so for other road users and the vulnerable road users.
And we've heard that your vehicle had 6 mirrors, is that right?
That's correct, yeah.
Can you remember what order you checked them in?
Well, I would have checked my near side first, then my offside as I was pulling out to the other carriageway. Then I would have checked my near side again, and then I would have gone round the corner.
And when you checked your mirrors, did you see the cyclist?
No, she wasn't there. I saw the lady with the pushchair, and obviously she stopped for me, but I never saw the cyclist.
We've seen the footage, but from your recollection, when did the collision happen?
It was while I was turning left, but I didn't know until I was waved down by a member of the public.
What about the pedestrian sensors that we've heard about? Did they sound?
Yes, they did.
Why did you not take notice of those?
Mainly because they go off all the time, even when there's nothing there.
It might be suggested to you that that didn't mean that you were paying proper attention to the road. Would you agree with that?
I pay even more attention to the road because I can't rely on the technology on the truck.
All right. Thank you very much, Mr. Brown. If you wait there, I'm sure there'll be some further questions.
Thank you. Yes, Miss Maire.
Thank you, Your Honour. Mr. Brown, your roadside account. I guess I should have thought, where has she gone? Is that an admission of guilt, Mr. Brown?
No.
No. Very much sounds like one, doesn't it?
Well, Your Honour, I hesitate to rise on the second question, but that's really a matter for the jury, not for the prosecution at this point.
Yes, I think in fairness, Mr. Rosser, you're right about that. Ms. Maire, you know, don't you, that it's for the jury to decide whether or not this defendant is guilty. And really, if you could concentrate your questions, please, on the facts, that'd be helpful.
Yes, Your Honour. I was merely putting his roadside account to him, but I will move on. So you're aware from the CCTV, aren't you, Mr. Brown, that the cyclist was travelling parallel, same direction as you? That much we can agree on.
Yes.
Yes. And you asked the police where she came from, but you saw her, didn't you? You admitted it.
I didn't know it was the same cyclist. As I said, I thought she'd gone off into one of those shops on the left.
Thought. She was travelling next to the cycle lane before moving into it, so she was cycling in a straight line, wasn't she?
Well, when I saw her, she was on the pavement, not the cycle lane. And like I said, I thought she'd gone off, doing a shopping or something.
And looking at the CCTV, you didn't stop before you turned left, did you?
The footage doesn't show the full manoeuvre. I had to slow really down to almost crawling to make that turn.
But we can see the cyclist is right next to your truck, yes?
Yes. But as I say, I didn't see her when I carried out my checks.
If you just waited, you would have seen her, wouldn't you? She would have had time to have cleared your path.
I did what I'm trained to do. If I see a hazard, I'll stop. If I don't, I have to carry on. I have to make some sort of progress throughout my day.
You didn't check properly, Mr. Brown. That's the truth, isn't it?
I was checking all the time to make sure it was clear.
And you just proceeded to turn left without stopping properly to check where that cyclist who had disappeared from your view, you didn't stop to check where she'd gone, did you?
Well, I virtually halted to nearly a complete stop to get round the corner. And I'm completely blind down that side. And like I said, you can't stop partway through a manoeuvre.
You keep saying you didn't see the cyclist, yet we know you did moments earlier. And you just continued to make your turn.
I checked all my mirrors. I couldn't stop for someone I didn't know was there.
Well, Mr. Smith, we know also that the pedestrian detection technology had warned you of this hazard, yes?
Well, yes, but it sounded lots. You can't rely on them.
Well, obviously you can, Mr. Brown, because it sounded and there was a hazard and you ignored that. That's dangerous, isn't it?
Well, I don't think so. And I do my own checks.
Now, we know the near side rearward view camera wasn't working properly that day, and the prosecution expert, the jury, you will have heard, has confirmed the cyclist would have been visible in that camera as you passed her. So perhaps if you'd noted this fault and this was fixed, we wouldn't be here today at all, would we?
Well, no, because you don't even look in them cameras when you're driving, ever.
Maybe you'd have known she was there if you hadn't been distracted by your phone call, Mr. Brown. That's right, isn't it?
I wasn't distracted. I knew what I was doing.
Yes, driving into a cyclist.
That's not fair.
Your Honour, I'm sorry, but this is already a very emotional and delicate case. Making comments such as driving into a pedestrian simply makes that task even more difficult. So I'd ask the jury invited to disregard what's just been said. Thank you.
Yes, all right, Mr. Rosser. Members of the jury, as I said at the outset, you've got to look at the facts in this case, and you've got to look at them objectively and in the cold light of day. And so, again, Ms. Maire, if you wouldn't mind, if we could just concentrate on the facts, please.
I'll rephrase, Your Honour.
Thank you.
So perhaps you'd have noticed the pedestrian if you'd had a decent night's sleep, wouldn't you? Would you say it's irresponsible to drive a truck whilst you're exhausted, Mr. Brown?
I've told you, I wasn't exhausted. I was fine to drive.
And yet, the fatigue detection technology within your vehicle identified that you were tired and needed a break, and only 48 minutes prior to the collision had flashed up. Why ignore that, Mr. Brown?
Because I knew I was okay. This stuff comes up all the time for no reason.
Well, evidently there was a reason, because you were tired and you ignored that warning. That's the truth of the matter, isn't it?
I wasn't tired. I didn't need the warning.
It was a dangerous manoeuvre whilst on the phone, exhausted, turning your vehicle, and with complete disregard to a cyclist that you had seen moments before, and you had no idea where she went. That's dangerous, isn't it, Mr. Brown?
No, in my mind, the road was clear, and the lady had gone off somewhere.
I've no further questions, Your Honour.
Thank you very much. Yes, thank you very much, Mr. Brown. You can return to the dock, please. Mr. Rosser, any more evidence?
Your Honour, yes. Could I please call the second witness to the defence, Catherine Draper, a forensic collision investigator who accepts instructions on behalf of the prosecution and defence, but in this case instructed by the defence. As before, rather than go through the qualifications, perhaps I can ask Ms Draper to present the key findings of her report.
Yes, please.
Thank you. It is probable that Mr Brown's attention was diverted to looking in his offside mirrors or into the junction as he manoeuvred the Scania towards the centre of the carriageway. As the Scania neared the junction, Mr Brown applied the left indicator, which in turn would have activated the audible warning, indicating that the Scania was turning left. Before the Scania started to turn left, the pedestrian stopped to allow Mr Brown to conduct his manoeuvre. At the same time, the cyclist passed the pedestrian and began to look to her left as she crossed the mouth of the junction. The Scania turned slowly, whereupon the front of it collided with the cyclist. Mr Brown had several blind spot areas around his vehicle where he would not have had a direct sight line of other road users. During the time that the Scania was adjacent to the cyclist on the footpath, adjacent to the cyclist on the cycle path, and crossing the junction, the cyclist would not have been within Mr Brown's direct field of vision, nor the near side Class 2 and Class 4 mirrors. Mr Brown would not have been required to use his close proximity mirrors, nor his CCTV monitor in these circumstances. At no time as the cyclist entered the junction did she appear to look in the Scania's direction until immediately before the collision. After the pedestrian had stopped at the junction and with the cyclist no longer in view, Mr Brown conducted his manoeuvre slowly as he negotiated the junction in the belief that it was clear. The Highway Code provides guidance for all road users. It states that it is important that all road users are aware of the Highway Code and are considerate to other road users and understand their responsibility for the safety of others. It also states that there is a need for everyone to behave responsibly. Having recognised what represented potential hazards and having duly considered them, whether Mr Brown could have done any more to have avoided a collision, given the actions of the cyclist, will ultimately be a matter for the court.
Thank you, Ms Draper. That's the evidence for Mr Brown, certainly.
I'm very grateful, Mr Rosser, thank you. So, members of the jury, as we said at the start, usually a company director would be tried in a separate trial, but for the purposes of this event, we're going to show extracts from both trials. So just turning to the company, you heard about the director, Mrs. Bryony. In her examination in chief, that's the evidence she gives when she's asked questions by her own counsel, she confirmed that she'd been advised that Mr. Brown had been tired. She accepted that the company did not have a written fatigue policy or mobile phone policy, and that they had known that the near side camera and sensor were not working properly on the truck that was being driven that day. And so that's her evidence in chief, and we're going to turn straight then to her cross-examination, please.
You a compliant operator, Miss Bryony?
Well, absolutely, yes. I like to think that we are.
One of the best?
Well, yes, it's a very difficult industry with lots of rules and regulations, but we have a real focus on compliance and health and safety.
Well, that focus doesn't extend to having a written and trained out fatigue policy, though, does it?
Well, we do have a policy, but unfortunately just hadn't had the time to document it, but there is a policy.
Were you too busy writing your mobile phone policy instead?
Your Honour, again, that's not the correct approach. It's not professional, and it's simply sought to be disparaging and to paint the defendant in a negative light in front of the jury. I would have expected better.
Apologies, Your Honour, I will rephrase.
Thank you.
You don't have a written mobile phone policy, do you, Miss Bryony?
No, we don't, but drivers know that if they're found to be using the mobile phone whilst driving, it is disciplinary action. In fact, it's gross misconduct.
Isn't a written policy the very definition of a policy?
Well, clearly I know now that having a written policy would have helped me, but I would say that is it better that maybe I don't have a written policy, but actually it is custom and practice that we have these policies in place?
Is it better? Well, I'm sure we'll let the jury decide that in due course, Ms. Bryony. So you said in your examination in chief that Mr. Brown had worked for you 14 years. That's correct, yes?
Absolutely. He's one of our best drivers, and you know it's just so difficult to get drivers now, so we really have to hold on to them, but he's excellent.
And you'd say you'd trained Mr. Brown well?
Over the years, yes, I would.
So coming back to the unwritten fatigue policy, what is it?
Well, of course, you shouldn't drive if you're tired, should you?
Well, I'm asking the questions here, Ms. Bryony. So you shouldn't drive when you're tired. Isn't that exactly what Mr. Brown did here, Ms. Bryony?
Well, no, as far as I was aware, he was fit to drive. He'd said he was in the morning.
Well, the thing is, you were aware, weren't you? You knew he was tired, you knew he hadn't slept well, and you sent him out anyway. That's right, isn't it?
I disagree.
Arguably, you knew he shouldn't have been at work, should he?
He told me he was fit to drive, that's all I know.
Only it's not all you know, Ms. Bryony, is it? You received data from the vehicle warning you of driver fatigue and distraction, didn't you?
Well, if you spend all day looking at every single bit of data from the telematics, you just get nothing done. And as a small operator, you just don't have the time and the resources, so we can't access all of it.
The question, Ms. Bryony, was you had received data and you knew he was tired and distracted. Had you or had you not received that data?
The data is not always foolproof. And we believe Mr. Brown was fit to drive, as he had said in the morning. And sometimes you have to rely on the drivers, the competent drivers, because sometimes the data is foolproof.
But this is data you can access and should be accessing, isn't it?
Well, certainly, yes. Our transport manager accesses the data, but not every minute of the day. It's just not practicable.
But what isn't practicable or reasonable, Ms. Bryony, is for you to totally disregard and ignore warnings that are designed to prevent tragedies just like this. That's not reasonable, is it?
I don't think we did ignore the warnings.
It's a habit, this, isn't it? This mismanagement and complete ignorance of data, that's a fair description, wouldn't you say?
I disagree.
So let's go to vehicle checks. You say they're carried out and any issues are rectified, but that's also not true, is it?
That is true. Every morning, drivers carry out a documented walk-around check, and we absolutely would not send any vehicle out on the road that was not roadworthy.
So can you explain why one of the cameras and one of the near-side sensors wasn't working at all that day, Ms. Brown?
Well, at the beginning of the day, when the walk-around check was carried out, the vehicle was roadworthy. And of course, nothing's perfect in the world of transport. During the day, things can and do go wrong that we have absolutely no control over.
Well, interestingly, Mr. Brown told the police that you advised him you couldn't afford to have a vehicle out of circulation. That's the truth here, isn't it?
Well, I don't think any operator can afford to have a vehicle out of circulation, but that does not mean that we would send a vehicle on the road that was not roadworthy.
As of you, really, it's a question of profit above safety. That's really where it is, isn't it?
It absolutely is not. We'd had the vehicle in the garage, and it's just absolutely impossible to get vehicles in the garage now. It's just, well, it's so difficult to do it, but the vehicle had been in the garage, and the mechanics in the garage had told us it was roadworthy as it was on the morning.
How many times does a piece of equipment have to fail for you to take action? Can you help the members of the jury here? Is it once? Is it twice? Is it 3 times? How often does that have to happen?
Well, I would say we had taken action because we'd had it in at the garage, and we believed that it was roadworthy, and it was roadworthy in the morning.
So to sum up, you knew Mr. Brown was tired, didn't you? You knew he was stressed.
Well, yes. We knew.
Yes or no, Mrs. Browning?
We knew that Mr. Brown was suffering, his wife was suffering, but every employee has issues, and if we said to every employee, stay at home, we simply wouldn't have anybody on the road because we all have issues in life.
Profit above safety.
Absolutely.
And you'd received warnings from the systems which you failed to react to. That's true, isn't it, as well?
We had reacted to what we knew.
And the jury have heard the company doesn't have any policies for fatigue or using hands-free devices, and you don't inspect the vehicle check sheets meticulously. Does that sound like a compliant operator to you? One that takes health and safety seriously?
That doesn't sound like our company.
Are you asking the jury to accept that you are a compliant operator?
I feel like I'm the one on trial here.
Well, if the cap fits, Ms. Friday.
Sorry, Your Honour, once again, it's just not helpful.
Apologies, Your Honour, I have no further questions in any event.
All right, thank you very much, both of you. Yes, thank you very much. So, members of the jury, that is all the evidence that you're going to hear in this case. You mustn't speculate about what evidence you haven't been told about. You must only try the case on the evidence that you do hear. And before I sum the facts up very briefly to you, we're going to hear closing submissions from the prosecution and then the defence, please.
Thank you, Your Honour. Ladies and gentlemen of the jury, the evidence in this case is clear and compelling, isn't it? I'm sure you'll agree. The prosecution submits that Mr. Brown's actions on that fateful day amount to dangerous driving. His driving fell far below standard that day for many reasons that I'll go on to address. But should you not be convinced that his driving fell far below the required standard, you must also consider whether he's guilty of causing death by careless driving, driving that simply falls below standard. His Honour will help you with that in his summing up. Either way, the inescapable conclusion is that Mr. Brown failed to drive to the required standard, and as a result, tragically, a life was lost. Let us begin with what we know. By his own admission, Mr. Brown saw the cyclist travelling parallel to him as he approached the junction. He assumed, without any evidence, that she was turning into a property on the left. But he didn't see her do that. Nor did he take any steps to confirm that assumption. He simply assumed. Is that good enough? You will decide in due course. Instead, he proceeded with his manoeuvre without stopping, without checking, and without any consideration for where that cyclist had gone. You'd heard from the defence expert that the cyclist was not visible in any of Mr. Brown's mirrors or direct line of sight at the crucial moment. But that, ladies and gentlemen, is exactly the point, isn't it? If she was no longer visible to him, then his duty as driver was clear to stop and ensure it was safe to proceed. Even the defence expert accepted that if there was any doubt, a driver should stop. Mr. Brown did not. He was aware of the cyclist's presence but chose to continue his manoeuvre. And in our submission, that's not just careless, that is dangerous. We must also consider the hierarchy of road users. Cyclists, as vulnerable road users, have priority. That is not disputed. Mr. Brown was under a legal obligation to give way. The defence expert again accepted that the cyclist's failure to stop at the junction was immaterial. She had priority. Yet Mr. Brown did not stop. Worse still, he stated in his evidence that there was no way he would stop. Now let us turn to the technology. Technology designed to prevent exactly this kind of tragedy. Mr. Brown's vehicle was equipped with pedestrian detection system. It warned him of the presence of a pedestrian, and yet he ignored it. Why? Because as he told us, it had become custom and practice to disregard these alerts due to previous false positives. This is not a trivial oversight, members of the jury. This is a conscious decision to ignore safety warnings designed to save lives. But it doesn't end there, does it? We know it doesn't end there. The HGV was also equipped with a fatigue detection system. And it warned Mr. Brown that he was too tired to continue driving and need to take a break. You'll all be familiar with that kind of technology. And again, he ignored it. And why? Because as he admitted, he knew he was tired. He'd had a disturbed night's sleep. You might think that his account given to the police at the scene, closest to the time of the collision, is very relevant here. and you will take that into account into your deliberations, I'm sure. And then the smoking gun, ladies and gentlemen. We come to the final damning piece of evidence just moments before this collision. Mr. Brown was on his phone, hands-free, yes, but nonetheless engaged in a conversation, perhaps a difficult conversation, you might think, in light of the worry about his wife. And despite being fatigued, driving a heavy goods vehicle, he was distracted, he was tired, and worse still, he was warned, and he carried on. Mr. Brown himself admitted as such at the roadside. He admitted, "I guess I should have thought, where has she gone?" And he should have, but he didn't. And that, ladies and gentlemen, is the crux of this case. His actions were not simply a momentary lapse in concentration, the prosecution submit. They were a series of conscious choices, ignoring the cyclists and her whereabouts, ignoring the warnings, ignoring the fundamental duty to ensure the safety of vulnerable road users. This is dangerous driving, isn't it? Plain and simple, members of the jury. However, if you find that that doesn't amount to dangerous driving and it doesn't meet the threshold of falling far below standard, which I think we can agree it does, he was at the very least driving carelessly, wasn't he? How can this be driving to the required standard of a competent and careful driver? Well, just common sense simply says that that cannot be true, doesn't it? Either way, Mr. Brown's driving was certainly not the standard that the law requires and that we expect as the members of the public, members, road users, everybody on that road. It cost a life, and for that, we urge you to return a guilty verdict. Thank you.
Thank you very much. Yes, Mr. Rosser.
Ladies and gentlemen, one of the first things you were told in this case, and you've heard it a number of times since, is to put emotion to one side. Where someone sadly lost their life, that, for this process, is not relevant to the evidence in this case. So for the Crown to say at the conclusion of their address that it's a reason to find Mr. Brown guilty is quite simply wrong. The reality is that there is a fine line between an accident and someone committing a criminal offence. This is no doubt a sad case, but it is in fact a very sad accident. It comes to something, doesn't it, when the prosecution say to you that there's a smoking gun, a damning piece of evidence, and tell you about a telephone call. Well, you know the evidence is that that telephone call happened a minute before this collision. No evidence whatsoever that Mr. Brown was on the phone at the time he made the manoeuvre, at the time he indicated, at the time the collision took place. And with respect to the Crown, to tell you it's damning and to tell you it's a smoking gun is quite simply desperate. Because in reality, this is a very simple case. It comes down to the footage and what Mr. Brown told you. But what's concerning is that's not the case the Crown have presented to you, because there's a consistent theme in the way the Crown have put their case, in the way the prosecution have described it. In interview, no reference at all to the fact the cyclist was on the pedestrian footpath, not on the cycle lane. Prosecution's opening, no reference to it at all. Prosecution told you about Rule 140 of the Highway Code, told you that it applies to those in a cycle path, using a cyclist junction. Didn't tell you in opening that in fact this cyclist was on the footpath. Prosecution expert didn't tell you when he gave evidence to you for the prosecution, had to be for the defence to ask, well actually it's right, isn't it? The cyclist wasn't in the cycle path at the point they could be seen. They were on the footpath. Perhaps most worryingly at all, in the prosecution's closing speech to you, again, no reference to it. Don't be misled into thinking that the cyclist was in the cycle path rather than the footpath, because that is a crucially important point. You've been told about what we call the burden and standard of proof. You have to be sure, in this case, as His Honour will tell you in a moment, that Mr. Brown's driving fell, for the most serious offence, far below standard of a careful and competent driver, and even for the alternative, fell below. And it's the prosecution that have to make you sure of that. Mr. Brown didn't have to give evidence, didn't have to answer questions at the roadside, didn't have to answer questions in interview, didn't have to be cross-examined as part of this trial. For you to convict him, essentially, you have to be sure that what he's told you in his evidence is all a lie. Dealing very briefly with the company. What's been suggested in quite a fierce cross-examination is ultimately perfection. You'll be directed by His Honour about looking at what's reasonably practicable, what's actually relevant to how this collision occurred. Ladies and gentlemen, I very strongly suggest that when you look at the evidence in this case, as you are required to do, the verdicts for both defendants on all counts are not guilty.
Thank you, Mr. Rosser. So, members of the jury, it is now my turn and my job to sum up the facts of the case to you, and I'm going to do that relatively shortly, and I also give you some directions in relation to the law. Remember that what you have to do is try the case on the evidence. What is said to you by counsel in their closing arguments is that argument. It is not a fact, and you can accept or reject it as you see fit. In relation to the facts of the case, it's been a very short case. You've heard the evidence this afternoon and it'll be fresh in your minds. But you know, don't you, that on the 18th of December 2022, Miss White was cycling home when she was involved in the fatal collision with the HGV driven by Mr. Brown. The prosecution case in a nutshell is that that was either due to dangerous driving or careless driving by Mr. Brown, and also by the fact that his employer, Freight Pink Limited, failed to do what was reasonably practicable to ensure that the truck and that members of the public and also employees were safe and their health and safety was kept safe. The defence case is that this is simply a tragic accident. Neither Mr. Brown nor his employer bears any criminal responsibility. As I said at the outset, you must return a guilty verdict only if you are sure of guilty. You have heard that Mr. Brown, an HGV driver for 18 years, saw the cyclist moments before the junction. You've heard that he assumed that she had veered off. He indicated left, checked his mirrors and turned. He never saw her again. The prosecution say he should have been more aware of her whereabouts. The defence argues that blind spots and other factors mean he could not have seen her. We've also heard about the vehicle defects, the faulty near side camera and sensors, and whether Freight Pink Limited met its safety obligations. Again, the prosecution argue that the company failed to rectify these faults and did not provide adequate policies such as the fatigue policy and the mobile phone policy. The defence say the company acted reasonably given industry standards and practical limitations. Now, just before we turn to how you deliver your verdict, I'd just direct you very briefly in relation to the test that you have to apply. In relation to dangerous driving and careless driving, in a way, you get both to be the judge and the jury in those offences because you get to choose what the standard is. Dangerous driving is falling far below the standard of a careful and competent driver. Careless driving is simply falling below the standard of a careful and competent driver. It's important to remember that no one in this case is suggesting that Mr. Brown meant or intentionally drove in the way he did. You must, as it were, apply an objective test to the evidence to decide whether or not you think the prosecution have proved so you're sure that his driving fell far below the standard, dangerous driving, or below the standard, careless driving. And I should say that were this a proper Crown Court trial, you'd now all be given a sheet of paper called a route to verdict, which would set out how you go about your task and make sure that you don't just have to hold it in your mind. No doubt you've forgotten most of what I've said already. Now, members of the jury, what I'm going to suggest, please, is that you now use your votes using the VVox to come to your verdicts. So what we're going to do, first of all, please, is count 1, causing death by dangerous driving. Have the prosecution proved so that you're sure that Mr. Brown's driving fell far below the standard expected of a competent and careful driver? Please vote now on count 1. Thank you. So then, members of the jury, we'll move on to count 2, which is causing death by careless driving. The lesser offence. Are you sure that Mr. Brown's driving fell below the standard of a careful and competent driver? Please vote now. We're now going to turn on to the health and safety offences. In law, these are in fact something called a reverse burden case. But in order to simplify matters, I'll take it relatively shortly. On count 1, this is under Section 2 of the Health and Safety at Work Act 1974. Are you sure that the company, Freighting Limited, failed so far as was reasonably practicable to ensure the health and safety and welfare of its employees, and that includes Mr. Brown? Thank you. And then finally, we're going to deal with the Section 3 offence. So this is count 2, Section 3 of the Health and Safety at Work Act 1974. And here the prosecution have to prove that the company failed to conduct his business in a way that ensured, as far as was reasonably practicable, that people outside the company, so other road users, were not exposed to risks to their health and safety. So please, can you vote now? All right, thank you very much.
Right. So I think, hopefully, we can see the results of your deliberations to see, hopefully, what you voted in relation to each of the charges on the indictment. So if those can be gathered and shown for us. Oh, so not guilty to dangerous driving, death by dangerous. Oh, Mr. Brown, you got away with that one. You're a soft lot, aren't you? Right, shall we? Oh, he's got away with it just, haven't you?
I will see them.
Yeah, you will see them, yeah. You are. You can tell this is a transport conference. Oh, no, not so much for you, Ms. Bryony. You're guilty. I'll tell you, there's a fair few that have rooted for you, though. I wonder what that's about. Maybe we'll find out in the Q&A. And what about Section 3? Nah, you're going down for that one as well. Thank you. You've paid great attention. Now, what we want to actually show you, does everybody want to know what actually happened in this case? Yeah? To see if you got it right or not? Yeah? Okay. So, basically, we had the company, you were right, guilty, as charged, 2 and 3. Although, clearly some of you, and you're right to be sympathetic to the company in lots of ways. You know, it's a commercial operation, you're trying to keep things going, you can't be everything, you can't do everything, and what is reasonably practicable, you got it right. Of course, they were guilty, and you'll see the sentencing exercise briefly in a moment. What happened? Causing death by dangerous driving? Not guilty. So you were right there. We managed to help Mr. Brown and get him off the most serious offence, which does carry life imprisonment. What happened for causing death by careless driving? It was close, wasn't it? But you were just about wrong. Actually, in that, of course, with juries, 12 people, generally you need a majority unless the judge directs a majority. So generally you need unanimous. So therefore, he probably still would have been convicted with that split. But yeah, for the purposes of what really happened, he was in fact found guilty of causing death by careless driving in real life. So we're just going to show you what actually happened in terms of the sentencing very, very briefly. So take it away, Your Honour, and we'll have the company first, please, Ms. Briney.
Yes, stand up, please, Ms. Briney. I've got to sentence your company for 2 offences, breaches of Section 2 and Section 3 of the Health and Safety at Work Act. As in any criminal sentencing exercise, I have to make an assessment of your culpability and the harm that's been caused. Applying the guideline as best I can, the culpability in this case is high. You failed to implement measures recognised as standard in the industry. We've heard the evidence that you failed to have in place a proper policy in relation to fatigue and mobile phone use. And you also failed to maintain sensors that you knew as a company weren't working properly. As I said, that's a high culpability case. In relation to harm, your failings led to a medium risk of harm. I come to that conclusion because, of course, the driver himself is also culpable in relation to his driving that day. The level of harm caused was the most serious kind. The collision resulted in death. I therefore move up within the category range to harm category 1. The company has a turnover of £5 million. That places it in the small company bracket. For a harm category 1 high culpability, the starting point of a fine is £250,000. That'll be paid, please, within 28 days. Thank you. Sit down. Stand up, please, Mr. Brown. You've been convicted, and I must sentence you for 1 offence of causing death by careless driving. I take into account all the mitigation that's put forward on your behalf, your previous good character. However, your comments at the scene indicate that you knew quite well that you'd taken an unnecessary risk that day. I take that into account. I cannot give you credit for a plea as you fought a trial. That doesn't mean you get a longer sentence, but it does mean that the sentence I impose must be that directed by the guideline. There's a heavy responsibility on all drivers, but in particular those who operate large goods vehicles with limited visibility. The victim in this case was a vulnerable road user. You were under a duty to make sure that you took reasonable care for her safety, in particular at a junction like the one that you yourself described as tight. In my judgment, this case does pass the custody threshold. The sentence I impose and the minimum sentence I can impose is one of 12 months imprisonment. You'll be disqualified from driving for a period of 3 years. That takes into account an extension period of 12 months under Section 35 of the Road Traffic Act. After you've finished your disqualification period, you will be subject to an extended retest. All right, thank you. Take him down, please.
Sadly, that's it for Mr. Brown. So That concludes our whistle-stop tour of the trial today. I'm really grateful for everybody coming back. If you do have any questions, whether you've submitted any or anything like that, then obviously we're around for a little while. But I'll hand back over to Kate.
Can we just have a huge round of applause for everybody? Also our departed actors here. Feels a bit sad giving a round of applause for a poor man being taken off to prison for a year, but I hope you'll agree that was a really, really thought-provoking and memorable reenactment that hopefully will give you at least some ammunition if you ever, unfortunately, find yourself in a similar position. We do have a few questions, so first question, I'm not sure who, maybe you could tell me who will answer this. In an incident similar to this, would tachograph checks be made to determine whether adequate breaks would have been taken and would mitigate any tiredness accusations?
Yeah, so as standard procedure with these sort of collisions, we will attend the scene, we will download driver card, we will conduct a 4 hertz data download on the tachograph. We can get up to 168 hours of speed data. We can look back through several months and we pour through that in forensic detail, not just looking at the tachograph, but also working time directive.
Would you take into account sort of, historical data? So say there was evidence of a pattern of behaviour. Is that something that you would take into?
Yes, absolutely. So we would look back through to try and establish if there are patterns of behaviour. There may have been previous infringements. If those have been eradicated, we would make reference to it, but also make reference to the fact that they've been eradicated over time. But if those patterns of behaviour have remained, that will be a relevant part of my report for the prosecution.
So keep your whistles clean and keep everything up to date. Next question. In this specific case, is any liability at all placed on the cyclist?
No, so it's, one, I guess it's in a little bit poor taste, it's considered in court to lay blame with the victim, but 2, all you are concerned about in a criminal trial, it's a little bit different in a civil trial where we talk about, you'll have heard of contributory negligence and things like that, where that comes into play. But for the purpose of the criminal offence, all you are looking at as the jury member is the standard of the defendant's driving. So that is what you have to look at. Yes, we're all human. I'm sure that juries occasionally do take those things into account. Where you make points in relation to that, you have to be very careful in doing so, don't you, Rhys? I'm sure you will agree with that.
Yeah, I probably wouldn't make the point normally, or do it in a more sensitive way, but
wouldn't make the point, yeah, okay. Final question from our audience, and then I have one myself actually. If I was to draft a policy for my drivers on what to do after a serious event such as this, what would it consist of? And I guess the follow-up to that is, should people have a policy for this kind of eventuality?
Yes, absolutely. And to be honest with you, don't sit there thinking, oh, I don't have a policy. That must mean I'm really rubbish or we're just not at the forefront of things. Genuinely, well, you probably know if you've been unfortunate enough to see me before at many places that I stand in front of audiences all the time, and the biggest of companies don't have this sorted. It's something that if you haven't been through before or you haven't heard of before, you don't always have it there. So many times, they don't have a proper crisis management policy, or you might have an accident policy, but that's for kind of, collisions where you're saying, take photographs, don't say anything at the scene, all of those things. That needs to be separated out. So what you need to have is an accident management policy for your kind of bent metal, your minor injuries, that kind of thing. And then you need a policy that is your blue light policy, which I know Rob would agree with, and he's a police officer. You need a blue light policy which says serious collisions that are police attended effectively, that needs to be a completely separate policy. So that needs to be instructions to driver, what to say and not say at the scene, ideally a phone number to get you through directly in those golden minutes that we talked about before the break to a criminal lawyer, not your insurance company, not FNOL, something that answers at all times, not your transport office, something that always answers, to provide that immediate advice and representation. And also make sure that you're not writing things down and documenting things and sending things off to insurers without that being in conjunction with your lawyer and protected by legal privilege. If you haven't heard of legal privilege before, that is effectively protecting it from the police and or the HSE being able to obtain those accounts that you write down. So you need to keep a very, very small network of people that are advised when something like this happens, and you need to not be pinging emails off here and there without that being protected and forming that protective bubble. Because otherwise, what can tend to happen is, in anyone's haste, thinking they're doing a good job, they're writing things down all the time, they're emailing things, and then if it's not done with legally privilege in the subject title and with your lawyer, then the police can knock on the door and take that. And that really upsets me when I'm in a police station and I've protected everybody, prepared a lovely prepared statement that protects everybody, and then the police shove something in front of me that says, well, your company says something a bit different when they're investigating. And often it's not deliberate, it's just things written in haste, things not thought through, or maybe you don't quite know the facts at that point. So again, your policy should deal with all of that. When this happens, you are not going to be thinking straight. So that policy needs to be foolproof, thought about, trained out, and everybody with a significant role needs to understand what to do when this happens. Because if it hasn't happened to you already, all that tells me is you're a day closer.
Yeah, can I just come in on that as well? Police do have body-worn video. It is a mandatory encounter on body-worn video that body-worn video is on at the scene of a critical incident. This would be a critical incident. That body-worn video is going to be recording from the moment I step out of my vehicle until the moment that I step back in. So everything is being recorded over that time. So everything the driver says is being recorded. Everything the driver is asked is being recorded. So the slightest slip of the tongue can put that driver straight away into the realms of causing death by careless, causing death by dangerous driving, unwittingly. Also, it can put you as a company representative into the realms of the Health and Safety at Work Act. So be very clear on what you brief out. All we need from a legal perspective at the roadside from your driver, name, address, date of birth, vehicle details, and insurance details. That is all that you are legally required to give me. If one of my officers asks for an account, a quick first account, seek legal advice. It is your rights, it is your entitlements, legal rights and entitlements. If the officer at that point gets a little bit narky and decides, well, to get an account out of you, I'm going to arrest you. It's arguable that that arrest is unlawful. At the moment, it's about £8,000 an hour for an unlawful arrest, so do your very best to stay in custody for 24 hours. But do make sure you've got that policy there. It's there to protect your driver when they are having the worst time of their life and they are suffering really significant brain trauma at that point, and they will say things without realising it. Think about what you've got in place. If you haven't got something in place, come and see me, come and see Charlotte. We can assist you with that. We work together really well.
Surprising, I know, but we do.
Brilliant. And I guess presumably in a similar way to our cybersecurity panel, the thing is practice it. Have a plan, practice it, make sure people know it. One final piece, if there's one thing, Charlotte, you've put together this wonderful presentation. If there's one thing that you want the headline that for our delegates to remember at the end of this, what is it?
So there are probably a couple of things because I always go beyond what I'm asked, sorry. So the first thing is what Rob and I have just said. What's your procedure in the golden minutes? What can you or your drivers, remember, this is not just relevant for driving at work. You all drive. It's personal driving too. Are you sorted? Do you have that number? Do you have that policy in place? Do you know what to say? Make sure you take that away if you take nothing else away. And the other thing, we're at a Microlize conference, we've talked about it a lot, but data. If you're gathering that data, you need to manage it. You need to be looking at it. You need to follow through on it. Have a look at your policies, have a look at what you've got, and make sure that you're following through and you can evidence it. Because any tribunal, be it a Crown Court judge, traffic commissioner, whoever it might be, they're not going to say, tell me what you do in relation to health, safety and compliance. They're going to say, show me. And you need to be able to document that and show that in any way that you can. So those are a few top tips. But we are hanging around a bit. I appreciate everybody. It's been a long day. You want to get on the road. But if you do want to speak to any of us, you're very, very welcome to do that as we're hanging around here.
Fantastic. And of course, our Q&A app is still live, so if you've thought of anything and you haven't had a chance to pose your questions, feel free to put it in the app. And Microlise has undertaken to get answers to all the unanswered questions and publish them at some point on social media. Thank you so much to our wonderful mock trial. Please give them a round of applause.